How are conflicts created? Conflict of interest is the term used to describe a clash between competing duties. A conflict typically arises when the legal professional owes a duty to two clients with adverse interests. They are typically created by these two parts: 1. Our continuing obligation to preserve the confidences of our clients creates conflicts of interest. 2. Our duty of absolute loyalty to each and every client creates conflicts. Whenever your duty to different clients is at odds with each other, a conflict of interest is created. Remember that we are obliged to preserve the confidences and secrets of a client indefinitely, even after the client's death, and that means our duty of loyalty never ends. A case that is still considered the legal authority for this principle is the 1975 case Silver Chrysler Plymouth v. Chrysler Motor Corp. 1. In that case, a man was employed by defendant's counsel as a law clerk and later as an associate for 3 years. Thereafter, he became a partner in the firm that represented the plaintiff. His former law firm, defendant's counsel, brought a motion to disqualify him from the case on the basis of conflict of interest, that he had secrets that belonged to the defendant that he gave to plaintiff's counsel, a violation of his duty of loyalty. In the opinion on the disqualification motion, the court acknowledged that it is common practice for lawyers to change jobs and that in the course of employment they have access to confidential information about the firm's clients. The court called it absurd, however, to assume that every lawyer in a large firm would have access to every client file and confidential information. The court held that if the lawyer's prior representation was substantially related to the present representation, the lawyer should be disqualified. A peripheral prior representation, on the other hand, would not be a sufficient basis for disqualification. The lawyer who had nothing, or very little, to do with the case while working at defendant's counsel should not be the cause of disqualifying plaintiff's counsel when that lawyer changes jobs. However, there is reason to differentiate for disqualification purposes between lawyers who become heavily involved in the facts of a particular matter and those who enter briefly on the periphery for a limited and specific purpose related solely to legal questions. The substantially related test from Silver Chrysler Plymouth is described more completely in LaSalle National Bank v. County of Lake, 2, in which the defendant's law firm moved to disqualify plaintiff's law firm because of defendant's former relationship with an associate of plaintiff's firm. On plaintiff's appeal, the court applied the substantially related test from Silver Chrysler Plymouth as the basis for determining disqualification. The court suggested this three-level inquiry. 1. The trial judge must reconstruct the scope of the lawyer's prior legal representation. 2. It must be determined whether the confidential information allegedly given over would have been given to a lawyer representing a client in those matters. A3. It must be determined whether that information is relevant in the pending litigation against the former client. If, after this evaluation, it is found that a substantial relationship existed, it will be presumed that the lawyer did receive confidential information during the prior representation. 3. In most jurisdictions, the court will not require that the two representations be identical, nor that the legal professional actually receive confidential information. The court will use the presumption from LaSalle National Bank. Intron v. Smith, 4. The court said, "It matters not whether confidences were in fact imparted to the lawyer by the client. The test does not require the former client to show that actual confidences were disclosed. That inquiry would be improper as requiring the very disclosure the rule is intended to protect. It is the possibility of the breach of confidences, not the fact of the breach, that triggers disqualification. Putting the burden on the former client to prove confidences were given to an earlier lawyer doesn't work. If you think about it logically, the client cannot very well say I told my former lawyer this confidential information. Because then the information will be released to the court and everyone else. It makes more sense to simply presume that if this lawyer worked on this case, in any depth, the lawyer has confidential information belonging to the client. And, of course, the same is true of the paralegal. Further, and perhaps this is the most odd part of this rule, the court will presume not only that the lawyer or paralegal walked away with client confidences but that upon getting hired at a new law firm gave all of the information to the people there. The court is presuming, then, that the lawyer or paralegal will not respect the duty of confidentiality. When considering accepting a new job, take a look at your state's Rule 1.9. It uses the substantial relationship test in setting standards for accepting new employment. A lawyer who has formerly represented a client in a matter shall not thereafter a. represent another person in the same or a substantially related matter in which that person's interests are materially adverse to the interests of the former client unless the former client consents after consultation, or b. use information relating to the representation to the disadvantage of the former client except as Rule 1.6 would permit with respect to a client or when the information has become generally known. So, new representation can't be the same or a substantially related matter if the former client's interests and the new client's interests are materially adverse. However, it's all okay if we can get the former client's consent. We discuss this in detail at the end of the chapter. The consent can simply be an agreement where we agree never to release confidential information about the former client or use that information against him. And, of course, the agreement must be in writing. This rule applies to paralegals when they change jobs. If the question has come to mind, if the identity of clients of the firm where I am working is confidential, how can I change jobs? I will have to check to see if I have any conflicts at my new job, but I cannot tell anyone the identity of any of the clients I have worked for? That's exactly the question that should come to mind right now. How, indeed? We cover this conundrum at the end of this chapter. What can the freelance paralegal do to avoid conflicts of interest? If you have a freelance or contract job, you probably work for many different law firms. However, your involvement in these law firms is not as deep as it would be if you are a regular employee of the firm. As a freelance paralegal, you work on just one case or an isolated group of cases. You are not on the routing list for firm interoffice memos announcing new firm clients. You are not in the need-to-know circle except where it concerns your particular case or cases. But, as a freelance paralegal, you may work for many different law firms and that may cause you to have conflicts of interest. The State Bar of Vermont took a look at this problem in 2002 and issued an opinion. It looked at Rule 5.3, on the duty to supervise non-lawyer assistants, and Rule 1.10, on imputing conflicts of one lawyer to the entire firm, and came up with this. In the case of freelance paralegals, the practical application of this, 5.3, responsibility is twofold. First, the hiring lawyer must exercise care to verify that the independent paralegal understands and has a system in place for protecting against conflicts of interest. Providing the freelance paralegal uses an appropriate method, the hiring attorney can avoid situations calling for disqualification by not hiring the freelance paralegal where there has been prior directly adverse representation. All other circumstances can be handled through screening the freelance paralegal from confidential information concerning other clients of the law firm. Second, the hiring attorney must also advise the freelance paralegal of the obligation not to disclose information relating to representation of the client and to maintain the confidentiality of that information. 5. That all makes sense. If the conflict is directly adverse, don't take the job. If the conflict is tangential, screening ought to do the try.